Yes,
My lord, at the instruction of my petitioner, I am going to withdraw item number 11, hearing item without any liberty.
okay. Why?
Oh, he is not conducting, maybe financially bankrupt or other reasons.
And on the prayer, Mr.
Or Islam.
R. Islam, learned counsel for the petitioner, submits that he has an instruction to withdraw his writ petition. Accordingly, writ petition
Without any
is
liberty.
dismissed without as on withdrawal. Huh? On withdrawal. Okay.
My pleasure, Lordship. Lordship, I'm praying for adjournment of item number 27, Lordship. It's
27.
a, yes, Lordship. It's a series matter, Lordship, from 14 to 27. I'm just making adjournment of 27.
Why?
Lordship? Lordship, I have some medical emergencies. I will have to leave the court, Lordship.
This will be taken up together.
Sir, Lordship,
Whatever decision is taken, it will cover.
Lordship, one by one, other senior counsel will appear. But
Hmm.
Lordship, as because
No,
I
you
have some
cannot
medical,
just segregate it. You ask somebody.
no, Lordship,
Would
I have,
hear you. What is there?
no, Lordship, I have some medical
Is
emergencies.
it can it be segregated?
No, Lordship, I'm not saying that, Lordship. Maybe for it can be for further hearing, Lordship, for in the next
We
day,
are taking
Lordship.
up today. It's okay. You
Lord-
be there.
No, Lordship, I will not. I'm extremely very sorry, Lordship. I will,
It cannot be segregated like that, sir. Once it is listed together.
Lordship. I understand, Lordship, but today I have some medical emergency. I will have to leave the court.
For that we cannot.
Then, Lordship, other person, other counsel will appear, Lordship, on behalf of me. Then,
Yes, yes,
Lordship.
yes,
May it please, your lordship. I beg to mention item number 2, your lordship.
yes.
I'm from the petitioner. I am appearing on behalf of S. Bothakur.
Hmm.
Today S. Bothakur has some emergency, Your Honor. We have taken the consent of the other party, of the opposite party.
On
We are
the
paying for
prayer
the
of Mr. So-and-so,
R.
learned
Ilhoka.
counsel appearing on behalf of Mr. S. Borthakur. List this matter after 3 weeks.
Obligor.
May please your lordship, with the consent of the other party, I beg to mention item number 8. I am here on behalf of Standing Council of Animal Husbandry and Veterinary Department, MM Kotoki.
Yes,
She is out of station because of the sudden demise of her mother-in-law. Her application of leave was already submitted.
2017 matter.
Yes, ma'am.
Yes. Which for the petitioner? Have you taken consent?
Yes, my lord.
2017 matter.
Yes, my lord.
Who is in bereavement?
MM Kotoki, Animal Husbandry and Veterinary Department.
MM Kotoge. MS. Your
R
name?
Kotoki.
Huh?
R Kotoki.
R Kotoge. Learned counsel submits that her senior Mr. MS.
MS.
MS
Kotoki.
Kotoki is in bereavement. Therefore, prays that matter may be listed after 2 weeks.
Much
Considering that the learned sending counsel Mr. Kotoki is Mr. or Mrs.
Mrs.
MS Kotoki is in bereavement. Come on, let this matter be listed after 2 weeks.
Much
My please, Lordship. Lordship, I'm praying for an adjournment in item number 9, Lordship.
9.
Yes, Lordship.
Why?
Lordship, may kindly accommodate for the day, Lordship.
Hmm?
Lordship, may kindly accommodate for the day.
Why? Why this is?
Today we have some difficulty, Lordship.
Huh?
We have some difficulty, Lordship. We have some difficulty, Lordship.
It's 2017 matter.
I understand, Lordship.
What is the problem?
Problem is my senior is not here today.
Huh?
My senior is not here.
Who's your senior?
A. Sharma. Kindly for the day, Lordship.
On the prayer of so-and-so,
L. Sultan.
learned counsel for the petitioner. Learned counsel appearing on behalf of Mr. A. Sharma on the ground that Mr. A. Sharma has personal difficulty today. Come on, let this matter be listed after a week,
Lordship.
after 2 weeks. Considering the matter is of 2017, no further adjournment shall be done. On the next- next
Milord,
matter. On
it's
the
regarding
next-
item number 10, Milord, hearing method.
Hmm.
It's of 2017, Milord. I am for the petitioner.
Ah.
Milord, I have some personal difficulty today, Milord. It's regarding selection and appointment to the post of university lecturer.
Hmm.
Lord, can it be in the next week, Thursday, my lord?
Why Thursday so many matters we have fixed so many?
My lord, since it's a hearing matter, either Tuesday or
What
Thursday,
is there? There's nothing.
my lord.
It's up to which selection process, which year?
It's of 2017, my lord.
Hmm.
My lord, that is why, my lord, matter may come up next week, my lord. Mm. My lord,
Are
on
you still,
Tuesday,
are you still serious?
my lord.
Are you still serious in the matter?
Yes, my lord. Since it's regarding, my lord, that tweaking of advertising, my lord, conditions, my lord. My lord, there is some specialization aspect, my lord,
Hmm.
but that specialization aspect has not been complied with, my lord. That is the crux of the matter, my lord. So, my lord, the matter may come up on Tuesday or Thursday, my lord, next week. And that will be, my lord, I will inform the other side, my lord.
On the prayer of Mr.
PJ Fupan for the petition.
PJ Pukon, then council procedure. Let this matter be listed after a week. It is made clear that no further adjournments shall be
My
made
lord.
on the next day, as the matter is pending since 2017.
Yeah. Can it be, my lord, on Thursday, my lord? Most obliged.
May I please the question?
So this is what-
That matter relates to my provincialization of service of the petitioner.
Hmm.
Worship.
Government advocate is required. He was asked to submit the records and along with affidavit. He is absent also. That is the last occasion, that's on that point, it was kept pending. One.
You recapitulate,
My lord.
refresh, please.
My lord. My lord, here is the petitioner, my lord, I take your lordship, some of the documents, my lord. Annexure 1, page 23, my lord.
Hmm. You just refresh. Why should go to the annexures?
My lord. Petitioner was appointed, my lord, 5th of January 2006, my lord. Assistant teachers. He taught social studies, science. Response number 5, 6, 7, 6, 7, 8 are also teacher. They discharging their duty and they taught 3 language teacher. Earlier, because of the non-inclusion in the provincialization manner by the district level security committee, petitioner approached before this honorable court challenging the appointment of the private respondent.
3 of them.
3 of them.
Yes.
During the course of the hearing, my lord, the learned advocate from the government side, my lord, stated that all 3 teachers were appointed as language teacher. It is appeared from the earlier judgment. However, the honorable court was pleased enough to pass an order directing the petitioner to file an statutory appeal before the
Appeal has been rejected.
appeal has been
On what
rejected.
ground?
Yes, my lord. The appeal has been rejected, though in the appeal itself admitted, they have stated, my lord, in the order, I was appointed as a social teachers, but others teachers who appointed in which categories as a provincial as a subject, that was not reflected. Though in the earlier judgment of this honorable court has clearly indicated that this petitioner, since appointed as a social science teachers, he has to submit all the documents. It is the mandate of the law as per section 3.1.11 that the social studies is a core subject amongst 3 subjects: language, science and mathematics, and social. So instead of doing this, my lord, the district level scrutiny, state level scrutiny committee director, my lord, passed the impugn order. Absolutely nowhere indication regarding the honorable judgments, honorable court judgment, so far the mandate of the law in respect of social science. While the entertaining this petition, this honorable court issuing notice, my lord, asking the government, if your lordship for a moment, the first order, my lord, the My lord, if your lordship, first order of this honorable court, my lord, dated 4/10/2023. My lord, para 4 I am reading just. Petitioner such and such claim provincialization under such and such as a social science teacher of the concerned school. The petition earlier instituted writ petition 1490/21, which was disposed of by this order, requiring the petitioner to file an appeal under section 14 Act of the 17 before the appellate authority, according the impugn order dated such and such had been passed. In para of the said order, it has been recorded that the petitioner Muhammad Sohidul Islam was appointed by the SMC of the such and such as assistant teacher on Iman. He was allowed to teach subject social science. In respect of the such and such, 4 teachers have been provincialized, namely Karim Khatun, headmistress, Mohanando Bora, science teacher, and Alamuddin, assistant teachers, and Salima Begum, both are represented my friend, assistant teachers. Among these teachers who were provincialized, nothing has been mentioned, indicated
Yes,
as
yes.
to who had been provincialized.
What's that? What's the last order?
My lord, 18/3, my lord, your lordship.
Page. No, that's last order.
My lord, impugn order, my lord.
No, last order.
My lord,
Order of this court
order of this court, my
in
lord,
the earlier proceedings.
my lord. Annexure 9, my lord. Page 49, start, my lord, it is start from page 51, my lord. The earlier proceeding, respondent number 5 appeared, my lord. This time, after earlier proceeding, respondent number 5 was appeared.
Who is-
Karima Khatun, Alaluddin, Salima Begum. These are the 3 private respondents.
Have been
Have been
provincialized
appointed
as
as language teacher, assistant. 3 languages. Tutor,
All are
all are tutor, all are
tutor
tutor in language, my lord.
in
subject not
language.
mentioned.
Subject is mentioned.
Subject not mentioned, all have been provincialized tutors, subject not mentioned. All are appointed as assistant teacher,
Assistant.
appointed
No.
by the Valley County as assistant teacher. Nowhere subject mentioned,
My lord,
subject to be taught by the person of my learned friends, appointed as assistant teacher, that is also not correct.
tutor, my lord, all are tutor. All appointments are tutor. Page 53 of the earlier judgment, my lord, para 6. My lord, your lordship got in, my lord. Page 53, para 6 of the earlier judgment. Mr. N.J. Khatinian, Learned Counsel for the Elementary Education Department, submit that as per the instruction he has received, the respondent number 5, 7, 8, whose services has been provincialized, are all language teacher. That is, my lord, English, either Assamese, Hindi, and Arabic. Now, social studies has been left out. My lord, show from the writ petition, some document obtained from the RTI, my lord, which is demonstrate that the earlier occasion, my lord,
You read para 8 also.
my lord. From the perusal of the material on record, except the certificate issued by headmaster, there is no document to show that the petitioner is a social science teacher. Yes, my lord. The dice code of the year which are on record shows that petitioner has been teaching language. My lord, now para 9, my lord. Learned Counsel for the petitioner submit that the insertion in the dice code as language teacher so far is petitioner is concerned is done by the principal, that is headmaster, as he has no hand to it, but in actually he has been teaching social science. At this stage, Learned Counsel for the Elementary Education Department submit that Act of the 2017 provide an appellate remedy under section 14 is the state government, and as such the appeal has been taken by the Secretary to the Government of Assam Elementary Education Department, and the said appellate authority as the mechanism to ascertain the fact. As such, it would be an interest of the justice. The petitioner is permitted to file an appeal challenging the provincialization
To
of
prove his case, social science and his court not been the deal with
Social
such textual details.
Now, my lord. the headmaster, my lord. My lord, I take a lordship, the certificate issued by the
No,
headmaster,
it's not settled.
my lord.
It's all submission of the learned counsel.
My lord, learned counsel. Now, my lord, one document, my lord, I am showing. My lord, I take a lordship, page 35, annexure 5.
Page 35.
Annexure 5.
What is there?
This is the format, my lord, while forwarding the format before the DSC, my lord. This is format SC science. I am coming, all this. Science, my lord. Shahidul Islam, my lord. In where my learned friends, private respondents, subject above my name, Manu Salima Khatun, Arabic, then allow this.
Who
in
has
the-
submitted this?
My lord, this is the format, my lord, educational professional qualification.
To the-
As a
to the,
teacher, tutor, my
for
lord,
su- for submission of
before the
district
DSC.
level is
yes, DSC, my lord.
district scrutiny
scrutiny
committee or what?
My lord, for provincialization of the
District level committee or?
district level committee, my lord. DSC, district level scrutiny committee,
DSC or DLC?
DLSC,
Are you sure?
my lord. DSC, district scrutiny committee, not level, my lord.
You find out?
My
from-
left, my yes, this DSC, my lord. District scrutiny committee.
Yes,
Now my lord, 2-3 documents I am showing, my lord, which was obtained,
it's okay.
my lord,
Yes. What is the impugn order?
my lord. My lord, page 57, annexure 11. Para 5 indicates, my lord, I am discharging as a social science. This is based on the record. Shahidul Islam appointed by SNC such and such. Headmaster once he allotted him to twist social science subject.
First scrutiny is included listed change. Proceed to
Hence, the committee decided to place the matter of provincialization of service of the petitioner before the SLSC. Now, my lord, interesting in next,
What is the reason of rejection?
my lord, since it was not placed before the DSC, this is the reason. That is why they appellate, my lord. Accordingly, the matter
Yes.
was placed.
Where's the record?
Appearing before the case Sharma, Sharma has written the record, full records are not did not reach today.
Huh?
It is not, the person is not able to produce today. They'll be sending it. But on 18th it was fixed.
Huh?
It was fixed. 18th last had come up the matter.
18?
18th of March, the matter had come up last.
Yes.
But the record was not, the council, Mr. P. N. Sharma had appeared, he has written to the department.
It's okay, we'll dispose it. Yes. Who amongst the
That is-
three
no.
language teachers?
Actually, that has to be
Just
clarified.
wait. Who amongst the three language teacher with junior mosque?
That is not a question here. Lordship.
That
Here
is the question.
No, Lordship. At the, nowhere says that appointment to be made on the basis of seniority. Act says,
No,
rule
no.
says, appointment to be made to the particular subject. That is the law. Nowhere stated anywhere, Lordship, junior or senior. Teachers to be appointed where minimum enrollment is found 30. 3 posts to be sanctioned. 3 posts to be sanctioned in an upper primary school.
So how many?
Lordship, yes,
How many
I-
posts?
under section 19 and 25 of the Right to Children and Free Education Compulsory Act,
Don't go
provides
that
there is
much.
no limitation
That
above.
no go much.
That
We'll
will,
not go into that.
no,
We'll
Who
not
shall-
go into that.
no, Lordship, here
You
is
just
the,
tell us,
no,
you
Lordship.
just tell
no,
me
Lordship,
how many language teachers have been provincialized in this case.
they are nowhere mentioned, all have, 3 persons have been provincialized language, all have been provincialized as tutor.
No, see, requirement is social science.
Yes,
mathematics, science
mathematics,
and mathematics,
yes,
and one language teacher. Minimum. Minimum.
maybe 4, 5.
Minimum.
Yeah,
I'm saying.
well, minimum, yes. Three,
So-
yes,
How you have been appointed? 3 language teacher have been appointed
I have,
without appointing social science.
no. Petitioner
You
number,
may
lordship,
you may appoint 3 science and
I
maths.
am not government, lordship, government
Just
appointed
listen.
me.
The government can appoint
Yes.
provincialized 3 teachers minimum.
Lordships,
Language, social science, science and mathematics.
Yes.
Thereafter, they can appoint as
appoint,
many as.
yes, anybody,
But here is a case, though the petitioner is a social science teacher, no one from the social science the
have been provincialized.
provincialized.
That is the
but-
submission,
but
my friend,
Respondent number 3 respondents have
Lordship.
been provincialized
lordship.
on 3 language teachers.
That is submission of my learned friend.
Assamese, Hindi and Arabic.
No, that is the submission of my learned friend.
That is the record says,
No, yes.
page 35.
Page 35 with the headmaster is prepared.
Ah.
It is not prepared with the government.
So it
Your
has to
lordship-
be, it's a format which is to be
That's,
formatted.
yes, lordship, there
And
is a dice code.
just wait. And what is the reason of rejection?
Region government can say, there is no reason mentioned, only I find in the impugn order, lordship,
Yes.
district scrutiny committee not selected the petitioner. That's why state scrutiny committee not
Yeah.
selected. That reason to be clarified by the government.
So we'll set aside
What-
this.
Set and remand the matter, what are the reasons?
We'll direct them to
No.
appoint
Which post, lordship?
social science.
Social science, there is a one, maybe appointed,
No, why-
three respondent,
You show us who
Yes.
have been appointed as social science.
all have been, that's why, lordship,
You tell us who have been, what are, which language, which subject you have
I am
been
Arabic,
Arabic.
Arabic.
Yes. Then
one is Korimun Nasa, no headmaster, Korima Khatun, respondent number 6, no headmaster post has been sanctioned. So far, my understanding
are
is
for?
concerned. I am respondent number 8.
you are
I am for
I-
respondent 7.
7. Who is for 6?
6,
no one-
no,
no one appeared.
nobody appeared.
6 is headmaster.
Head,
No, Karim,
Sir,
not
no,
headmaster.
head miss, he was
Karima Khatun.
Korima Khatun. Whether his post, her post has been provincialized as headmaster or provincialized as social science, that has to be clarified by the government.
That
Because-
is the problem. Respondent number
please.
7 and 8
That's why-
canvassing on behalf of Karimun, who is not before your lordship.
That's,
They have to plead their own case instead of going here and there.
He is a party.
No,
Oh,
he is a
she-
party.
she is a
Service is complete.
In this,
yes,
Yes.
she has
in this
one
matter,
point, lordship.
You make your submission. We'll just record it.
Lordship,
We're disposing of the matter.
3 persons, provincial, 4 persons provincialized, one Mahananda Bora, science teacher. He's having
No dispute.
yes, no dispute. Among the 3, there is a dispute because 3 have been provincialized as tutor. No subject mentioned.
No, my lord.
That cannot be done also.
Page
Why my
35.
learned friend
Page-
is-
page 35.
This is not correct.
Malay, it is his document.
My document,
page
where is
35
my document? Is the
Malay,
headmaster? She has no authority to say.
Page 35 make
Page 53, kindly be say. It is whose document? Headmaster is clarified. That's why my learned friend has not challenged the provincialized, only mentioned in the name. No statements, no pleadings at all mentioned in the writ petition. The hard service to be set aside. In the prayer also stated, in connivance with the headmaster, my learned friend always trying to say, this was prepared by the headmaster.
Don't go about it.
So,
Make your
it-
submission. We'll record your.
kindly prior to that, lordship, page 49. Your lordship, page 49
What is
of the
it?
earlier round of litigation. Earlier round of
I've seen
litigation,
it.
page
Tell,
49.
tell us.
Yes. Paragraph number 8,
Hmm.
page 53.
Hmm.
May I read, lordship?
I have read it. You tell us.
From a perusal of the materials on
You tell
record.
us what is there.
No document found that he is teaching as social science. Or he thought social science.
It doesn't say.
Rather language. In the dice code tells, in the dice issued by the Sarvashiksha officer, wherein says that learned friend is teaching language. That's also government record. Only this is the private record prepared by the headmasters. Other government records say he is also language. That is in the affidavit lordship, kindly see. That is important. Lordship. My learned friend claims is social science. Page 170, lordship.
170.
Yes. One 64 is the first prior to that. Look, I'm sorry.
Which affidavit?
It was affidavit of number 8.
There's no 170.
One prior to that, I'm sorry, 167. Starting from 167. This is the
records,
district inform system. Lordship got it.
records is
Lordship
up
got
to
it. Data capture format.
108.
Data capture format. Page starting from page 6.
The record is up to 108. Page 108. You are referring to page 167.
What? Yes,
167.
yes, yes. 167.
Yes.
This is Unified District Info System for Education, UDICE. Your next page, Lordships, page 168. Lordship, second column, Korima Khatun. Top second, third line name. She is respondent number 6. Lordship got it. After third column, Lordship,
Yes.
name of the teachers, Lordship will find one Korima Khatun. Lordship got it. Korima Khatun, respondent number 6. Lordship, in the bottom portion, Lordship, middle portion, find she is teaching all subjects, mathematics, science. Lordship got it. Next teacher 2, Alaluddin, respondent number 7. My learned friend is respondent 7, wherein nothing has been mentioned regarding subject. Respondent number 8. Then Salema Khatun, I am appearing. Arabic, yes. Then Shohidul Islam, lead petitioner, shows languages, all subjects. Then it was, yes. Then it was next page also. This is also 1920 UDICE code. Says page 170. Alaluddin names is appearing Salema Khatun.
Your documents.
Yes.
This is your
Salema Khatun.
documents.
Oh, here also says all subjects.
This is your documents.
No. It is prepared by the government. Suppose Shiksha Vijay, not my document. It's a government document, authority. Dice to be issued. Dice to be prepared by the Sarva Shiksha Lordship as per section. Dice code Lordship, page 103 Lordship will find of my book, this book Lordship, 10, page 103. Who will prepare dice code? Page 103 Lordship. This
For what?
book. Dice, who will prepare the dice? Here mentioned. Section 2I. 2I, small I. Dice code means District Information System for Education Code prepared by the Sarva Shiksha Abhijan, Assam, and is available in the records of the National University of Educational Planning and Administration, New Delhi. So my learned friend says she is teaching social science, but here in the government record says, DICE says all subject. Nowhere, even say one of the column find language also. Nowhere say it as social science. Is the claim of the petitioner. That's why 3 persons.
It's okay.
What
We'll send it back, remand it back. And
Lordship.
to work out whether there is to find out whether the petitioner is a
Social science.
social science teacher
And
and whether the respondents by 6, 7, and 8 have been appointed as
Which subject?
language teachers.
Or
In the event, if no appointment is made in the social science subject, and if the petitioner is a social science teacher, he should be appointed. That's all.
My lord, take it, yeah, all right.
Yes.
Taking into 2 documents, for a moment, take a
No,
little
we'll
bit.
not
No.
say all this.
My lord,
No.
they are,
We'll go for the record.
Go.
yes, my lord, records, my lord, just, yes, my lord, page
one
59.
submission.
Heard, Mister.
One submission
right.
plus one
That's
small point. Lordship, government provincialized three teachers, one science board. The 3 have been stated tutor. Against which post their service have been, but that has to be also required to be clarified.
It's not your petition.
My lord, my lord,
Lordship.
only 2 documents, for a moment, just for a moment. My lord, page 59 and my reply in affidavit 185. Just 2 documents. This is a current document, 2024.
We're not here to decide.
Yeah, that is true, my
That's why
lord.
we wanted to see the record. They have not failed to produce the
My lord,
record.
my lord, in the order, my lord, so that we can peruse these 2 documents also. Petitioner is given liberty to, it is their
It's
document.
not job of our, it's not our job.
Yes, my lord,
That will be
it is
done
my
by
duty to, my lord, point out.
authorities.
Yes, my lord. Obviously, my lord, page 185, for a moment, my reply in the affidavit, they have filed, my lord. Only 1 paragraph. My lord. This is a document of 2024,
Not necessary.
my lord, 2024 document, my lord, 185 page. He is the member secretary of the DSC. Well, that is why earlier occasion, this honorable court, after perusing this, sent this.
Which way?
This is a district limited irrigation officer who is the member secretary of the DSC to
Where it is?
director.
Which page?
Mal page 185.
185 is something else. There's no 185 in fact.
Mal in reply, reply by the petitioner against the affidavit filed by respondent number 7.
Hmm. But that
Sorry,
is-
187 one. Sorry, mal 187.
Hmm. District elementary education.
Officer, he is the member secretary. With reference to the subject, I have the honor to state you that
We'll not go
Mohammed
into all
Shahidul
this.
Islam appointed as assistant teacher.
We'll not go into all this. We're just sending it back. All right.
Madam, just taking into this note, madam, my submission is we will liberty to produce all the documents. Well, we will produce these documents also. Well, because they suppress this, the district elementary, the input order has not indicated this report. That is why I have been given a liberty to submit all the necessary documents. Your lordship, remand back, consider. Set aside this order, my lord. Let them take a fresh decision. Well,
Heard, Mister?
AK Hussain.
Huh?
AK Hussain.
A.K. Hussain, learned counsel for the petitioner. And also heard learned standing counsel, elementary education department for respondent 1, 2, 3, 4, and 5. Hmm, that's right. Huh? 3 to ensure.
MA Hussain for respondent number 7.
F.U. Borboya, respondent number 8.
Non-APS for the
Respondent number
Please
6.
come on. Non-APS for the respondent number 6. Desperate service of notice. Next, madam. Challenge made in this petition is to the order dated 16/06/2023, passed by the Secretary to the Government Assara, Department of Education, School Education, whereby the claim of the petitioner for provincialization of he or she has service as social science teacher has been rejected. Rejected on the ground that the District Scrutiny Committee, Nagaon, has not recommended the name of the petitioner for provincialization of his service. Mr. The case projected, no, the case of the petitioner, son of unnecessary details, is that petitioner was appointed as assistant teacher in the Pachil Moira Das MB Madrasa on 05/01/2006. Mr. In terms of the the petitioners claims to be a social science teacher and the social science teacher, whereas the respondent number 6, 7, and 8 are language teachers. Mr. Out of 4 teachers in respect of the Pachin Morida ME Madrasa service Madrasa school. This is Madrasa. It is contended that services of respondent number 6, 7, 8, who are language teachers, have been provincialized, along with one Mahananda Bora for science and mathematics. And the case of the petitioner, although he is a social science teacher, has been ignored. It is contended that the as per section 3(1), you remember that 11 of the Assam Education Provincialization Act 2017 provides that in case of Benson Upper Primary School, there shall be minimum 3 teachers or tutors, at least 1 teacher each for science and mathematics, social science, social studies, and languages. The petitioner, no, it is contended that the non-provincialization of the service of the petitioner, who is a social science teacher, while provincializing the services of the respondent numbers 6, 7, and 8 is in violation of the aforesaid provision. Mr. Next paragraph. Agreed by such action of the respondent authorities in not provincializing the service of the petitioner. He approached this court by filing writ petition being WPC 1490 of 2021. This court on 3/05/2022 disposed of the writ petition with a direction to the respondent authorities. No, while not interfering with the appointment of the respondent 6, 7, and 8. And taking into account of the allegation and counter allegation, particularly taking into account that the petitioner should be given an opportunity to prove his case that he is a social science teacher, and the court would not be in a position to deal with such factual determination that too in a proceeding under 226 of the Constitution. Directed the petitioner to file an appeal under section 14 of the Act of 2017. Before the Secretary to the Government of Assam, Elementary Education Department. This court had also observed that has also recorded the submissions of learned Standing Council for Elementary Education Department, that as per the instruction, the respondent number 6, 7, and 8, whose services have been provincialized, are all language teachers. It also, the court has also made an observation that on the perusal of the materials, on the court accept the certificate issued by headmaster in the year 2017. There is no document on record to show that the petitioner is a social science teacher. The DIC code of the years which are on record shows that the petitioner has been teaching language subject. Next paragraph. The petitioner has filed a statutory appeal before the responding authority. And accordingly, Mr. On receipt of, on such appeal, the Secretary to the Government of Assam, Department of School Education, has disposed of the appeal as directed by this court in the writ petition within the bracket clause, and rejected the writ petition, and rejected the appeal of the petitioner on the ground that the case of the case of the petitioner has not been recommended. The case of the on the ground that the district scrutiny committee has not recommended the name of the petitioner for provincialization of the service. One language teacher, not less than one language teacher in a bachelor school. You should get the 11. That's all. Yes.
I am for the respondent number 7, my lord, and
Well, you're same.
admittedly, I am a language teacher. I am the senior most language teacher, and so far the Poriman Khatun is concerned, my lord, that clearly reflected that she is not the language teacher, my lord. Rather, she is teaching all subjects, including maths and science, my lord.
Who?
Respondent number 6, my lord.
Why are you appearing for responsibility?
No, but this is my submission, my lord.
Documents,
Document shows that
dice
that
told.
shows that Poriman Nasha is not a language because the education is that Poriman Nasha and
Is a science and maths.
she's including social science, my lord. She taught all subjects, including social science, science, math. This
What does it say?
does that shows
It shows that it's a social science.
it shows she's taking classes in all subjects, including
Mr. So learn concept for the respondent number 7. While subscribing to the submissions of learning council for the respondent number 8, comma submits that the respondent number 7 is also a
language, senior
language
most language.
teacher whose service has been provincialized in terms of the provisions of the
Provincialization.
2018, 17 Act. Huh? Will give the act something, Assam something like that.
One
Education provincial act.
submission.
Enough.
One.
Are you going to devote your case whole day? Yes, what is your stand?
Okay, as far as the department stand is concerned, we were supposed to produce the records, but as far as the technically, 3111 says that there has to be a social science teacher, there has to be a mathematics teacher, and there has to be a language teacher. Now, Lordship sees the record. The social science part is disputed. They are saying that they are social science. So that part, since that part is disputed, then that matter will not be sent back. The authorities may scrutinize the
Yes.
documents which they have produced as well as them.
Mr. N.
Then a
Foucault.
patient hearing will be given.
N.
According to
Foucault.
the reason of
A. Foucault. A. Foucault, Learned State Council for Elementary Education
Right.
Department. Submits that, although he could not obtain the record as directed by this court, fairly submits that. As per the available records, it appears that no teacher has been appointed in the social science subject. List of the respondent number 7, 6, 7, and 8 have been provincialized as tutor in language subject. Therefore, he fairly submits that. No, Mr. He submits that the grounds of rejection by the in the impugn order that it's so and so. It also appears to be that the name of the recommendation, the name of the petitioner has not been recommended by the District Scrutiny Committee, as the Act mandates that for provincialization of service of the teachers, public tutor of the Bachelor School has to be placed before the first place before the District Scrutiny Committee And on the recommendation of the District Scrutiny Committee, the further scrutiny would be, is required to be done by the state levels scrutiny committee. Therefore, he fairly submits that matter request to be reconsidered as the real issue of whether the petitioner is a social science teacher or any teacher of tutor has been provincialized in the social science subject, and the and whether the petitioners, the respondents 6, 7, 8 have been appointed only in the language subjects. The matter may be remanded back to the respondent authorities. Next one. I've considered the submissions of learned counsel for the parties. And also Paris director. Where is the materials available on record? Next one. The respondent authorities have failed to produce the record. This were repeated direction for production, having been considered the issue in question. Next page. Is noted above, this court in the earlier round of proceedings in WPC, writ petition Supra, having considered the allegations and counter allegations, and also considering that considering the claim of the petitioner as social science teacher, request to be given an opportunity to place his case before the respondent authorities. Directed the respondent authorities to consider the materials which would be filed by the placed by the petitioner, and to take into account the mandate of law that there has to be a social studies teacher in the venture school in terms of the so and so Act of 2017. Next paper. Records available. And the materials available on record in the pleadings, in the writ petition and the counter affidavits indicates that the petitioner, and not only indicates that the petitioner is a social science teacher, but also indicates that he is indicate that he is also a language teacher. to which this court would not be a proper forum to adjudicate such contradictory documents and the claims and counterclaims. It is true that the in a Bansari school, a minimum teachers teach of science and mathematics, social studies and languages are to be accounted in terms of section 3(1)(11) of the so-and-so Act of 2017. The respondent authorities have not been able to provide the record and also fail to indicate whether the respondent number 6, 7, and 8 have been appointed or they provincialized. The services of the respondent number 6, 7, and 8 have been provincialized on which subjects other than the languages. Please. If the respondent 6 and 7, 6, 7, and 8 have been provincialized, services of the respondent 6, 7, and 8 have been provincialized only in language subject, the such provincialization would run counter to the mandate of the law under under the so-and-so Act 2007. As three teachers, each of three subjects, i.e. social science, science and mathematics, social science and languages are to be mandatorily appointed, provincialized in the bench of wisdom. Is noted about, it is not discernible from the record available as to whether the respondent 6, 7, and 8 have been provincialized. Services have been provincialized only as a language teacher or any other subject. Yes. Perusal of the interim order that is 16/06/2022. Shows that the rejection, the consideration and rejection, the consideration of the case of the petitioner pursuant to the order of this court, that is 13/05/2022. And consequential rejection is only on the ground of the name of the, only on the ground that the district scrutiny committee has not recommended the name of the petitioner for provincialization of service of his service. Therefore, the state level scrutiny committee has decided to reject the claim of the petition. Although it has, it indicates, it has mentioned the relevant provisions of so-and-so Act 2017, bare perusal of the said impugn order, the above impugn order clearly shows that the consideration appears to be on irrelevant and without taking into the relevant consideration. Mr. Does, I would review that the impugn orders the view that the responding authorities have failed to consider the case of the petition in its proper perspective and as per the provisions of the so-and-so Act. And as such, the impugn order cannot be sustained. It is not sustainable. In view of the discussions and observation made very above. Among the future, the respondents authorities are desired to be directed to reconsider the case of the petition, taking into all the relevant facts, including as to whether the petitioner is a social science teacher or the and the respondent was 6, 7, and 8. The services of the 6 respondents 6, 7, 8 have been provincialized as language teachers or any other subject. Accordingly, the respondent authorities are directed to reconsider the case of the petitioner. Taking into consideration by taking into account the claim of the petitioner that he is a social science teacher and also the respondents number 6, 7, and 8 have been appointed only as a language teacher, provincialized as a language teachers or any other subject teacher, public tutor. Mr. In the event, if it is found that the petitioner is a social science teacher and the respondent number 6, 7, and 8 are the submission to the respondent 6, 7, and 8 have been provincialized only as a language teacher. The petitioner would be the petitioner be considered for appointment in a social science subject. Social science subject as it would be as per the requirement of the provisions of so-and-so Act 2007. It is, however, provided that if the respondent authorities and the respondents 6, 7, and 8 have been provincialized as only a language teachers the respective authorities may consider retaining them as the in view of the in view of the this code that in view of the fact that the provincialization of the services of the teachers and the tutor as per as per section 317 appears to be a minimum of 3 teachers where there is a scope of appointing as provincially more than 3 teachers in a given venture school. The writ petition stands disposed of in terms of the above observation and direction.
There is not a minimum 3. There is as per RT clauses above 3 in the Act also says clauses. Even has to be more than 5, 6, 7. Here the more enrollment more than 100.
More than 100.
That's why 5 teachers required. Here in this.
What I've said, have you heard it?
Early, it is
You take it out.
lost one
It
submission.
will be uploaded.
Lost
If you have anything to say,
interim order. Stands
go to
required.
that. Huh?
There's an interim order is
Till
operating.
the appointment is, till the consideration. No, yeah, the whole exercise. Before that, huh? As directed here above shall be made within a period of 3 months from today
Receive of the certificate.
until the and the
Even from receipt of the certificate.
certified copy of this order, Mr. Till just consideration. No, will not say.
Interim order marks with the final order.
My lord, in this
Sir,
regard, my lord,
my
I have a
IA is
submission.
pending.
I is pending, my lord.
That's why required to be
This
modified.
I stands marked, I stands closed.
My lord, in this
lost it,
regard, I
but
have a
so lost
Say, will say.
One
Yes, yes.
submission
It
was
is to say that the provincialization of the services of the respondent number 6 and 7, 6, 7 and 8
8.
shall be subject to the outcome of the final decision as directed herein.
In this regard, my lord, so far as respondent
Thank
number
you.
7 is concerned, my lord, he is the
The
senior
IA, in
most,
all IA, in view of the disposal of
he is
the
the
petitions,
senior most language teacher, my lord.
closed, huh?
7 is the senior most language teacher. Whatever it happen, my lord, respondent 7 will be remaining, my lord. So that may be.
We're not, we didn't ask, I have not asked
Lost it is
anybody
not
to
setting
be
aside anything.
dislodged, right?
Yes.
We just said, even if you all have been, are provincialized as a language teacher, there's a scope of retaining you. So that
Yes.
may be considered,
Yes.
but it's up to them.
We are
Whether
working, but
they-
no salary, my lord.
We
Huh?
are not getting, we are
But-
serving,
Serving, but-
salary is not getting.
Keep serving, because
But
if you
I am
feel-
also serving, even not.
Where
getting
is
there,
he serving?
They
Well,
are
thank
also
you.
getting services.
There is no school at all. The beige, provincialized in the beige school.
it's good, you are teacher, you keep serving,
In
forget
the
about the
earlier round
salary.
of litigation, my lord, my service was state. but
Thank
later
you,
on,
next.
No.
Thank you.
The
sir.
Lord,
Yes,
Here, some time is required, my lord.
why?
As per last order, my lord, regarding, I have to take instruction regarding the portal uploaded, uploaded.
Small matter, this-
Yes, madam.
What is your instruction? It's a age
From the
of
finance
digi-
department, it is not coming, coming, and
digitization.
I have not received it, madam.
Agree to release the area sale in compliance with the order of this court, and that the proposal for director has been received and the department is proceeding for releasing area sale. Concurrence of final is required for drawal and that the proposal is ready for uploading. What do you mean by proposal ready for uploading on reopening on the? So until and unless the finance
Yes,
gives It's concurrence.
Yes, yes, financial
She
concern.
cannot be paid.
Yes,
Huh?
yes.
According to you, is it a mere formality or is it who has to decide that whether she is entitled or he is entitled or not?
Already government from the department has agreed that the area salary is there. Here, my lord, it is the last instruction. Inviting reference to the subject, I am directed to say that department had agreed to release the area salary in compliance to the order of the Honorable Court. Proposal from Director Secondary Education Assam has been received, and this department has processed the proposal for release the area salary in respect of Sultana Ahmed, additional teacher, Upper Hali High School, under the Kamrup district, so and so head of account. Now the concurrence of finance department is required for drawal, and the proposal is ready for uploaded on the reopening of the portal by the finance department.
Is it which date?
It is instruction of
13/3.
13/3/2025.
So
So after that, my lord, I have not received any instruction.
you have
So,
not asked for any instruction. That's the problem.
no, we have already communicated,
So
ma'am.
ask.
Yes, my lord. In our WhatsApp group, we have communicated.
group, WhatsApp.
She does actually communicated, as because she is last occasion appeared in.
In view of this direct, in view of this communication, yes,
Yes,
we're closing the writ petition
yes,
to pay the area salary within 2 months. All right,
yes.
Yes, ma'am.
will not record anything. Can you? Because you have decided to release.
Yes.
It appears to be a
But
mere official formalities.
yes,
Already sanctioned, my lord.
Holiday sanction, you have ready to.
it is
to pay.
waiting for uploading the portal in the finance department. As per that instruction.
So we'll close it.
Yes, ma'am.
Paid within 3 months, 2 months.
2
3
months.
months, 3 months.
No, no, my lord.
If
Already
it is completed 2 months, well and good, then they will come. Otherwise, 3 months.
Huh?
If it is, yes,
Why not proceed you? What
Yeah.
would be the, reasonable time? Since when you have not been getting the salary?
For 17 months, from September 21 to February 23.
Now you are getting the
Yes,
current
I am
salary.
getting, presently I am getting the current salary only for 17 months.
Let us give them 3 months.
It will,
So
they
that
will
because,
again take time, my lord.
we want to ensure that it should be given. Tomorrow
Yes,
is true, even if you direct the 2 months. Because
Furthermore, my lord, her
official,
husband, our-
official procedure also requires.
yes,
something.
required.
my lord,
Get
her
sometime-
husband also died few months back, my lord.
I understand. That's the reason why we should have this kind of, when the method is, maybe you have a very good case or whatever, the pending a case before the court is also a big,
Yes.
it distracts the mind also. We will not record anything in view of this, we'll direct them to pay within 3 months. All right,
Yes, yes.
and MS Swain, learned counsel for the petitioner. And Mr.
You, Sharma,
U. Sharma,
for secondary education.
learned standing counsel for,
4 and 5.
huh?
Respondent number 4 and 5.
Who are you?
Hard name.
Huh?
Hard name. Respondent number 4 and 5.
Who is 4 and 5?
Who?
Yeah.
I am for the 1, 2, and 3, my lord.
Record them. Huh? This writ petition. Has been filed by the petitioner. You are a teacher or what?
Yes, my lord, I am a teacher, my lord.
Who is working as, who is working as assistant teacher
Assistant teacher,
at Upper Hali High School.
high school, my lord.
List of, for a direction to the responding authorities to release the monthly salary from the month of September 2021 till the current salary of the petitioner is paid. This one.
Yes.
Next para. By next para. The communication dated 13/03/2025
September
from the Secretary to the Government of Assam, Department of School Education. Comma.
September 21.
21.
The respondent authorities
To February.
has agreed to release the area salary in respect of the petitioner. Listed. It appears that the only hiccups for release of the said area salary
My lord, from September 21 to February 23.
is due to due to want of concurrence of finance department, for which the petitioner, with the respondent authorities are are seriously pursuing. Mr. What are you saying? What do you
No,
saying?
my lord, the period is from September 21 to February 23. 17
Then
months.
in that till payment of current element, huh?
My lord,
September 21
First,
21
First
to-
September 2021 to 28 to 2023.
we'll say September 21 to February
February
2023.
23.
Huh? That which where are the till you just delete that till payment of sales, huh? Huh? Next one. Having considered the clear categorical stand of the respondent authorities that a decision has already been taken and they have agreed to release the area salary claimed by the petitioner. I deem it appropriate to close this requisition with a direction to the respondent authorities to release the amount to the petitioner. Accordingly, this petition is closed with a direction to respondent authorities, particularly Secretary
Secretary,
to the Government of Assam,
Secondary Education Department.
Secondary Education Department, to release the area salary claimed by the petitioner for the period from September
September 21,
2021 to February
February
2023,
2023.
within a period of 3 months from today.
Obliged, my lord.
The petition stands disposal.
But here the selection process of the assistant professor
Yes,
was not concluded because of the flood in a different district.
yes.
So therefore, they are required to conclude it. Instead of that, they have cancelled it. This is my lord, totally unreasonable and arbitrary. There are two decisions of the Supreme Court. Unless there is a good reason, you cannot cancel it. We have completed the process in respect of others, we have appointed also.
Hmm.
But thereafter, my lord, they have taken a decision to cancel it. Your lordship can see page 25.
What is the decision?
First decision is page 25.
Lordship, we have filed affidavit that is not on record, your lordship. Lordship, on 21st of March, your lordship, it is not on.
You are for Dibrugarh University.
We
No,
have
it's
not-
for
I am for principal and president, your lordship.
Which-
Restaurant
which-
number 4 and 5.
which university?
No, it's a college, lordship, not
It's a college.
university.
College of
Yeah, lord.
Under Guwahati University,
what
We
university?
are the,
Assam University.
Assam.
let it be on record, your lordship. Any other, in the
Next
month,
week, my lord,
next
on
week,
Friday,
on 8th of April, your lordship, if possible, your lordship.
8th of April.
8th of April. Small accommodation.
Where?
By the time affidavit will be on record, your lordship, and
It's only in respect of only one subject.
One subject.
one subject.
Political science, this is a reserved category. Unreserved category, they have filled it up.
Hmm.
And
So what is the reason here?
reason, your lordship will kindly see page 25.
Remain inclusive owing to the sudden suspension of all the activities under assembly and flood havoc of the adjoining localities of Halakandi.
Here is stay also, lordship, in their favor.
It said,
It
it is
says,
decided
okay.
to hold the same interview after the restoration of the normals. This flood has occurred in different districts,
Hmm.
and you should complete the process. If it is
Then
not
when's
completed.
the cancellation?
Cancellation is, my lord, your lordship will kindly see governing body's resolution. That is at least 26. Resolved that a fresh interview be held for the post of boy, suddenly without reasons. So and so cancelling the interview held on so and so as the said interview remained inconclusive. And an inconclusive interview has to be concluded. It cannot be cancelled, my lord. Owing to the sudden suspension of all activities under Assam University and flood havoc of the adjoining localities of the, this is Hailakandi, but this is in respect of different district, my lord. Flood occurred in a different district altogether.
So cancellation is page 31.
26 and then 31. Status report was given. Impugn order is at page 31.
Basis College Halakandi and directed to refuse to take measures to conduct a fresh advertisement.
Yes.
An interview the post issue in the department building. Cancelling the interview then. Deputy Director of Higher Education. Simple.
Page 14, para 12. of
Where
the-
is there is a reason, I mean, what is the ground of
Lordship,
cancellation?
We have
Why
filed
not
a
saying
detail-
that you cannot? You
lordship, we
may,
have filed a
but
detailed affidavit.
you
on
will have
record.
to show the reason. Then
Then-
we'll take it up on 8th.
Yes, lordship.
Or Mr. B.D. Das, London, Senior Counsel Assisted by London Counsel for the petition,
R.H. Chaudhary, lordship.
Mr. R.H.
For R.H. Chaudhary for 4 and 5, your lordship.
R.H. Chaudhary.
For respondent number 4 and 5.
Submits that. Yeah, an affidavit in opposition on behalf of respondent 4 and 5 has been. Has filed, when?
21st of March, your lordship.
Has been filed on 21/03/2025. However, same is not placed with the record. We will request that the matter may be adjourned to 08/04/2020.
They have to produce records, earlier order is there.
Yes.
The London Senior Counsel to the petitioner. No, they are not being objected for adjournment by the London Senior Counsel. Let this matter be listed on 8/04/2020. Mr. Swain, London Counsel to produce the record. As
Right.
directed by the lawyers. Yes. This for what?
I filed interlocutory application in the IM, this has already been disposed of. In the interlocutory application, I prefer it because certain clarification regarding the other person,
Cannot.
not,
You want that the review has been, it has been directed to consider prospectively.
well, that is the, well, what
That is
happened.
the view.
well,
of the
in fact,
court. How can we correct it?
in fact, annex one or that provincialization order that has been passed in 14 May 2013.
So
In
that
the
can
order
be-
itself, it is clarified that with effect from
It
1/1
may-
2013,
Huh?
It is clarified in the order
Yes.
that
Which order?
that annex one order
The
by
order
which
under
the
which you are seeking a correction.
by which the services of the petitioner herein were
Something,
provincialized.
huh,
That with effect from 1/1/2013, that order still hold the fields. That
Who?
is not interfered by the any subsequent order. So
so
while
how
the-
can we just correct
Malad,
like
I'm
that?
coming, Malad.
We cannot correct this.
Malad, I am coming, Malad. So while
I have seen it.
Well,
It cannot be case of correction.
while while passing the order in the writ court, Malad, on 12/12/2019, on that there is a curfew. That is why I as a counsel cannot attend the court. The ex parte order was passed. That is why I prefer the review. In the review petition.
Why it should be corrected? Tell me.
Well, since you also can you look into the annex of 1?
It is contrary to the parent order or the order passed in judgment and order passed in the writ petition, according to you.
My lord, in the judgment order passed in the writ petition, there is a, my lord,
It clearly says that this is from 01.
my lord, in fact, my lord, the order pursuant to which I prefer the writ petition, that is
Yes.
a order dated 14 May 2013, that is
Yes.
annex of 1 to the instant IA.
Yes.
That order, it is clarified, government while provincialized the service of the petitioner, it is clarified that the with
should be-
effect from 1/1/2013,
1/1/2013, right?
13, they will get the benefit for provincialization.
1/1/2000.
My lord, while
Just wait. 1/1/2013.
13, my lord. Well,
Then you filed a review.
I filed a writ petition, my lord. Since the order passed,
After the order in that case.
my lord,
In the writ petition, what is the order?
my lord, writ petition, my lord, in absence of us as a council before the court, on the due to curfew, we could not, I explained the review petition. That is why I could not
So why-
attend the court.
which
The
order-
ex parte order was passed. In the paragraph 12 of that order, finally
Of what?
dispose
Of,
of the writ petition with the
okay.
direction to give in the prospective effect under 2017 Act.
Yes.
In fact, there is no whisper in the petition.
Then you file
Then
a,
I
file a
prefer the
review petition.
Review petition.
so read review.
In the review petition, the paragraph 12 of the writ petition, that has been clarified that it will be benefit as to be given under 2011 Provincialization Act 2011 as amended at 2012.
Hmm.
My lord, the word prospective effect hampers me because the department has, my lord, understood that prospective from the date of passing of the order. In fact, the prospective ought to have with effect from 1/1/2013, as has been reflected in their government's provincialization order dated 14 May 2013 at Annex 1 to the IA. Prospective, because that order has not been touched by any authority. That has
cannot
been,
be a case for a simple correction.
Malad, that is why the clarification, because in
No, we
subsequent
cannot-
communication, director indicates the authority, departmental authority, that you have to process their salary with effect from passing of the order. In fact, Malad, passing of the order, prospective effect ought to have 1/1/2013.
This IA, present IA is for what?
I have for the clarification regarding that the word prospective
No, we
effect
just cannot-
doesn't mean that
We cannot
with
clarify.
effect from date of
We cannot
provincialization,
clarify. It's
date
clearly-
of passing of the order.
There it clearly says prospective.
My
We
lord,
cannot change it.
my lord,
According to your, this prospective.
that is why
creates-
we want a
creates-
clarification
no, no,
from
that-
your lordship, my lord.
We cannot.
A simple clarification
No, no.
regarding prospective
No, no.
effect
Sorry.
means with effect from 1/1/2013, because
Okay,
this order is as on date, the order dated, that is Annex 1 passed by the government, whereby my services has been provincialized,
Sir,
is
it-
wholly
It
field.
would amount to review of the order again. So
Malad,
that is
it's a
cannot be a
clarification. The
No,
clarification that
sorry.
prospective effect means that
How
we
can we
different-
say that? The court has wrongly or rightly recorded the word prospective.
I am
has
coming
a-
for your
has a-
lordship. I just point out my
It has
grievance, my
a-
lord.
It has a
Yes, my lord.
implication.
It's up to your lordship. I cannot say anything more. I just project my difficulty because the authority has, subsequent to the order passed by this honorable court,
Thank you,
directed the
sir.
junior
I
officials
find-
that
I find that this is not a, the the order cannot be simply corrected by way of this IA. You have the remedy. You have to avail the remedy. I'm just indicating. Why this it's not a case of simple
I am
correction.
before the yellow says as decided, mal, I
Okay,
cannot,
Mr.
mal,
Mr.
I just, without any.
Heard Mr. UK Goswami, learned counsel for the petitioner, applicant. Having perused the integrity application, this court is prima facie of the view that there is no ground shown. There's no ground set out in this application for correction of the order dated so and so passed in review petition. Which review petition?
Well, 67,
67 of
67 of 2000, well,
Is
20.
it would amount to review of the order dated so and so so and so. You'll find it out, huh? In view of above, Mr. Goswami is granted further 2 weeks time to reflect on the issue. Think about it. Otherwise, I'm dismissing.
Mal, hello, plus mal.
It's not a ground for.
No.
I'm indicating it's not a ground for correction.
Mal, mal,
Case of a correction.
mal,
Avail the appropriate remedy.
mal, hello, plus
It's a matter of form only.
mal.
May I please your lordship, when
Yeah.
I am appealing for 1 to 6.
Yes.
I have actually whatever some of the papers are not there. I need only my 1 day time. So matter may be fixed day after my lord, because just now only from the department I have called some papers, my lord. I have got it now. So day after this may be taken, my lord,
What
as the
is
first
this?
item.
What is the matter?
Can it be on 31st then?
What is the matter?
My lord, the petitioners are, my lord, working as charge mechanics in the border road organization.
Hmm.
My lord, there are other similar persons of the same grade.
Hmm.
They approach this honorable court by filing a writ
Yes, they are saying the similar relief.
No,
At
no, no,
least
my
we-
lord, it is because last time I have gone to it is not similar, my lord. This is not similar, this is
No,
not.
no, your spin may be that these those who have been granted that 6 pay scale,
Yes,
I mean, expired 6 pay.
they are not in the same footing
Their
with the,
appointment were earlier
yes,
and these petitions are subsequent.
yes, my lord.
Subsequent to the order or
Yes,
subsequent to
yes.
the 6 pay commission, something like that.
Yes, my lord.
Is not
So
it?
they are not with a similar footing.
It
with
may not be a good
Ghanshyam
grant.
Sharma market.
I am granting today, but
Today, day after, my lord. Yes,
Let it
I
on
said it.
31st, my
31st.
lord. Let it be on 31st.
I think prima facie you need to.
Yes, I
You have to
understand.
grant. Similar relief.
Yes,
We don't
no,
have
no,
to,
I'll satisfy your lordship.
only you have to show that why they are not entitled, why
Yes,
they
yes.
cannot be provided with similar relief.
Yes,
The grounds of rejection has to be reasonable. I mean, it should be in accordance with the law.
yes.
Not
According
just-
to us, my lord, they are not charge mechanics.
Huh?
They are not charge mechanics. I'll satisfy your lordship, my lord.
I don't think so.
I'll go
Charge
through it
mechanic may
with
not
just
be
now
a-
only.
may not be a dispute. Only dispute may be difference of the time of appointment.
Yes, exactly.
They are
exactly.
creating a class within class.
Yes, that is the only issue. That is the only issue.
Then on Friday, your lordship.
Last,
As you.
not Friday.
Friday.
When?
No, that is holiday.
Oh, acha, okay. Any day, my lord, any day.
No. Friday, let it be on Friday.
No, Friday.
Adequate.
What?
Not April.
Third is difficult. Third I won, I will not be here.
Then after Bihu,
No, let it be up before that. Fourth,
only I have.
Huh?
Huh?
let it,
10th. Actually, we have
Okay,
fixed so many matters.
Okay.
Not Mr. P.K. Roy Chaudhary, Land Council for the Land Senior Council assisted by Mr. B. S.K. Chakraborty, Council for Deputy Senator.
Why Doloi?
And
Senior Penal Counsel from Indian of India for 1 to 5.
on the prayer of Mr. Y. Dollar, Land Senior
Penal Counsel
কবে?
That is
কোথায়?
senior CGC.
Or let it be on Thursday, my lord.
The
Thursday.
prayer not been objected to by
Okay.
learned
Thursday?
counsel for the petition, learned senior counsel, huh?
Thursday, my lord. Next. This Thursday.
This Thursday, which day? We're fixed.
28, 28, my lord. Oh, no, for
Huh?
Friday, 27th. No, April. 27th, yes, yes.
Friday. No, না করে।
Hmm. This Thursday, not possible. Either 3rd or 10th.
Out of ten. Huh?
First
First April.
First April, yes. First April.
Tuesday,
First April.
1, 2, 1, 0. What I said? No. On the prayer of. And then on the prayer of Mr. White London senior CGC. And not, and the prayer not being objected to. By the, no, and the, and as agreed to by London senior counsel for the petition from this matter on to be on.
First of April.
First April.
First of April. Obliged.
Have you the watch, my lord?
Yes,
Please, my lord.
what is the matter?
The matter regarding my lord, he is break-in service, my lord.
Hmm?
And he was, when he was ultimately appointed as the original post, my lord. Just before going to the facts, my lord, I'm just going in this, my lord, just. Initially, he was appointed in 1988, my lord. Because there was some problem, he was posted in Nagaland, then he wanted to get transferred to Umrangso, Karbi Anglong.
Hmm.
Then a police case was lodged against him for a different reason, my lord. So since he was there more than 24 hours, my lord, he has been suspended. After suspension, my lord, he got transferred, my lord, and he wanted to join, my lord.
Yes.
And he was not allowed because of lack of medical certificate. Proper medical certificate was not given. In this manner, my lord, there was some other incident, my lord. Ultimately, he decided to tender his resignation, my lord. Tender his resignation, my lord, in 1992, my lord. So since then, my lord, there was no connection with the office, my lord. He had to undergo some psychological treatment also, my lord, in this long time of near about 9 years, my lord. In 2001, my lord, whatever, my lord, when he recovered, my lord, that he decided to go to office. If there is anything for his pensionary benefit or anything he will get or not. When he went there in 2001, my lord, he found that his resignation, which was submitted in 1992, has not been accepted, my lord.
Hmm.
It is pending. So he immediately filed application, my lord, for joining, my lord. So he was not allowed, my lord. In the meantime, his resignation has been accepted, my lord, in 2001. Then he filed a writ petition, my lord. In that writ petition, that acceptance of resignation part of one of the order I will show, my lord, that has been set aside. And the matter is sent back to the department to consider his case. Accordingly, the department was kind enough to reinstate me, my lord. The department reinstated me in 2014, my lord. The case was disposed of in 2009, my lord. And I have been reinstated in 2014, my lord, in the original post, my lord, estate engineer. So, no, but since case
From which year?
in 2014.
In the same post, but with effect from 2014,
Yes,
not before that.
not before.
Okay,
That is the break-in service, my lord.
yes.
So my submission that, my lord, since in 2002, my lord, I challenged that order before this honorable Guardian. But since 2002, my lord, of course, there is a break-in service, no work, no pay, I understand, my lord. But since
No,
my
it's
resignation,
okay, you have your acceptance of resignation
yes,
has been set aside,
set aside,
sent back.
yes,
You have no issue.
no
You
issue,
have been reinstated
yes,
from the date of that order of reinstatement.
yes.
Then
Yeah.
but thereafter we'll see. not before that.
Yes, of course, of course.
Yes.
Now, here, my lord, since one of the order, my lord, into, that is the imperial order, that order which has been challenged, my lord. One part, my lord, the department said, my lord, that no departmental procedure has been initiated against me, my lord.
Huh.
I
So-
show your lordship, my lord.
Why, how you are agreed? What is the prayer grievance here?
Yes, 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 yes. My grievance, my lord, yes, I'll show, my lord, that since, my lord, my my acceptance of resignation of 2002 has been set aside, my lord.
So,
So from 2002, my lord, since I filed this petition before the summer of Guwahati Heaven 2002, my lord. That is at
I
least
say,
some,
what is your grievance?
that my grievance, that the break-in service, break-in service, my lord, has not, has been,
What is
That,
your
my lord.
order of reinstatement? Let
yes,
us
yes,
see.
tell it, without hearing, my lord. Because your
That
lordship,
was
I
the
show,
reading.
yes, yes. I show the imperial order, my lord. That is, your lordship, page 58, my lord.
58. What is this?
Yes, that is my lord, release of substance, that is after my joining, my lord. That is a type copy, original, that is, Xerox copy is there, my lord. Next page, my lord, 58.
50?
8. There's type copy, the Government of India, Brooklyn compound, your lordship got it, my lord.
Release of substance.
Yes, I made a prayer, my lord. Release of substance on full pay, other constitutional benefits, and period of absence from duty may be treated as period spent on duty. Okay, sir. In continuation of your earlier letter, of our earlier letter, SL serial number 11, I am directed to convey the decision of the competent authority. The period of long gap of absence shall be treated as break-in service and shall not draw any substantial allowance owing to not reporting during the period of suspension.
This is of 2010.
2010.
And when you were reinstated?
Yes, yes, reinstated 2000, not 2014, reinstated 2009, man. That 2009, prior to that, 57. Page 57.
Joining corporation. This
Yes.
is not,
With reference to, it is to inform that competent authority has allowed to join in the substantive post cap in view of the Honorable High Court's order.
where
Subject,
is that order?
yes, that is there, my lord. That is, my lord, your lordship will find it
45.
page 45, my lord. Page 45. It's a long order relevant portion, your lordship. May,
No, any order passed by the authority reinstating you. This is High Court order.
yes, yes, that is the order, my lord. That is the order of page 57, my lord.
Page 57 is your joining
No, my lord, joining in the corporation, that is by the authority, my lord.
Mohammed Ayub Hussain.
Yes.
It refers
be
to
by.
the, it is to inform that the competent authority has allowed you to join in the civil in view of the Honorable High Court order, subject to provision, the production of your medical fitness. So you have joined
Yes, sir.
2009. When?
That is, the joining report is not there, my lord. In 2009, I joined, my lord. After that, my lord, the subsequent order, that is imperial order has been issued, my lord. That page 58, my lord.
What the court has said, as far as your claim is concerned,
No,
the
but
concept therefore acted as
Guwahati High Court, my lord, simply set aside the acceptance of substance, acceptance of resignation by the authority. The imperial order has been issued, my lord. This is all right, my lord. The thing is that regarding this break-in service, no prior notice has been issued to me regarding this, my lord. I've been practically, this order has been passed. I was totally unaware, my lord. I was not called for to by issuing any notice, my lord. Only when I apply for this, all these subsistence allowance, all this backlog benefit, my lord. How much backlog benefit, that is up to the department, whether I am entitled or not. But in the meantime, when they replied, they showed me
There was no departmental proceedings,
no departmental proceeding. You
only suspension.
no, my lord, suspension has been withdrawn, my lord. My lord, page 42, my lord, annexure, and that is the correct document, my lord, which was challenged before the Honorable Guwahati High Court. One part of it, page 42, annexure N, my lord. My lord.
Yes.
Yes, may I read, my lord? Yes. Consequent upon the voluntary submission of resignation dated 1/1/92 addressed to Chairman and Managing Director NEPCO Limited Shillong, says the criminal case disposed of and acquitted from the criminal charges later on by the Honorable Court in respect of Ayub Hussain, Junior Engineer, Grade 1 Civil. The Chairman and Managing Director Shillong has accorded approval towards acceptance of resignation tendered by Ayub Hussain, so and so. That is in 2002. That is the next part, my lord. It is certified that no vigilance and disciplinary cases pending or contemplated during the service period of Ayub Hussain, and accordingly Ayub Hussain stands released from corporation with effect from 1/1/92. Now next part, which has been challenged, my lord. Suspension order, no, that shows that my suspension is revoked, my lord. Suspension order issued under memo number so and so dated 11/10/91 in respect of Ayub Hussain hereby revoked since criminal case, PS case number so and so, and acquitted from criminal charges. That was issued in 2002, my lord. That is since 2002, I was not under suspension. First part I challenged, my lord, before this court, my lord, challenging my acceptance of resignation. That has been set aside. And so far as the suspension as part is concerned, that has been revoked by them itself. So from 2002 onward, I feel I am entitled by it. Because they have revoked my suspension. And they themselves said, my lord, in 2, my lord, paragraph number 2, no vigilance case has been registered and no disciplinary proceeding has been pending or contemplated.
What do you want?
I want, my lord, of course, break-in service, there is a long break-in service. But
So-
since my suspension has been revoked, while order dated 27 February 2002, my lord. At least from the date of revocation of suspension, because I was not provided a subsistence allowance. That is also there in my prayer, man. I was not provided a subsistence allowance.
When you were suspended?
So, because I was arrested, my lord, in a case, my lord, more than 24 hours I was there in the case, my lord. That criminal case also I have been acquitted. It is there in this document itself, too. I was suspended because of this criminal case. And kindly see, my lord.
I'm asking when you were suspended?
Yes, my lord. I was suspended, my lord, 11/10/91. And suspension was revoked in 2002.
Then you have joined in 2009,
2009, after the court order.
91,
Yes.
2000.
Well,
20
it's a
years.
peculiar case. But since my lord,
Yes, what is this?
my lord, I don't know, my learned brother will see.
Have you returned now?
Yes, I got retired in 24, April 24, 2024.
Forget it. Enjoy your evening of your life.
Only thing some benefit my lord was my, because since 2002, my lord, my suspension has been revoked, my lord.
Yes. What is your stand?
Your Lordship, there are two parts to it. One is with regard to the subsistence allowance that he is seeking for the period of suspension. The other is the break-in service. Now, in the initial writ petition which he has filed in the year 2002, he prayed for the payment from 1991 onwards. That was not granted by this honorable court.
Any observation on that?
There was no observation. But I will still say, by way of constructive res judicature, it should be deemed that his prayer has been declined, because the court only went to set aside this acceptance of withdrawal, resignation, and remanded the matter to consider whether he should be allowed to join or not. The prayer, if I may just pray, this is not on record, Your Lordship. The prayer
That was withdrawn.
joined in his post by order and further direct the payment to pay up his monthly salary since November 1991 and after. Yeah. So that was not there was no prayer to that. Para 13, if Your Lordship may just see. Itu na, itu video na, itu top na itu. Na, itu apni copy digital TPF 2002.
Yes,
That's my first. Second, Your Lordship, under the applicable rules, the conduct and disciplinary rules, a person who is placed under, an employee who is placed under suspension is bound to report on daily basis if he is to be entitled for subsistence allowance. Admitted
bound
position,
to,
he is bound to report for duty. Once he is placed under suspension, he cannot leave station and he has to report for duty. That is provided in Rule 24. In the instant case, admitted position from 91, the petitioner has not reported for duty, at least has not reported. Being so, we have stated that since you have not reported during the suspension period, you are not entitled for subsistence allowance. That is the order that has been passed, Your Lordship, in Annexure R, page 58. That has been mentioned. Now, with regard to, admittedly, he is not in service.
where is that?
Page 58.
58.
The bottom line. Your Lordship may not read both together. Break in service is separate and subsistence allowance is separate. Page 58 of the writ petition. Conduct and disciplinary. Not enabled to draw subsistence allowing owing to not reporting during the period of suspension.
58.
Yes, Your Lordship, page 58. Type copy.
You convey the decision, which one?
In continuation of our earlier letter, am I with Your Lordship on that? That last line, second last line, and not unable to draw subsistence allowing owing to not reporting during the period of suspension.
And there it convey the decision, we come out that the spirit of long labor absence shall be treated as break in service and not unable to do the senior. Yes. That, so what that rule?
Yes,
Sir,
24.6 missing.
It's for NEPCO only.
Yeah, it's for NEPCO. Huh? Okay.
24 point?
24.6.
The suspended employee shall not leave the station without its information. The employee under suspension will report the reporting. Have you deducted?
We have not paid only. We are not to pay.
What does it say that you will not be entitled? Where does it say that it will not be paid?
Your Lordship, I'll just,
Without entitled. It says, in case if we fail to report, only you have to deduct from such period. You have to deduct it. There is something,
then we'll
deduction
deduct it.
is something different. It doesn't
no,
say,
that is a
it
case.
cannot be permitted that you will not pay at all.
Your Lordship, Your Lordship, if I may just have it, copy to the.
Give it. In case an employee under suspension does not report in the office as mentioned, and the sufficient allowance for such period is liable to be deducted from the sufficient allowance so period. Yes. There's a provisional payment. You cannot have a different thing.
Your Lordship, can I make a submission here because it has to be read with Rule 26 also, treatment of the period of suspension. That also has to be read. Where the employee under suspension is reinstated, the computer may grant to him the following pay and allowance for the period of if the employee has not awarded any pay, so the full pay which he would so if he has not been unless the service already paid to him. If otherwise, such proportion of pay and allowance as the competent authority may prescribe. In a case falling under the period, it will not be treated as period spent on the. In case falling under, it will not be treated as period spent on duty unless. Your Lordship, let me just take the instruction on what provision they are doing. But my instruction is that he did not admitted position, he did not report for duty. That is there. So whether he will be entitled, Your Lordship is absolutely right.
Yes, heard Mr. So and so, learned counsel for the petitioner. After hearing the, no, after hearing the learned counsel for the justice assembly, Mr. D. Senapati, learned counsel for the petitioner. No, after arguing the matter at assembly. Mr. D. Senapati, learned counsel for the respondents, all respondents.
All responded, no?
All
Six,
2 to 8.
six, an adjournment, the matter to obtain certain, obtain instruction to ascertain certain provisions of the, what is that? What is that rule?
Conduct, discipline and appeal rules. NIPCO
Obtain-
conduct.
To obtain instruction with regard to certain provisions of the northeastern conduct and
Conduct, discipline and appeal rules,
NIPCO.
not NIPCO.
NIPCO conduct, appeal, and
Discipline,
discipline rules.
discipline and appeal rules.
Discipline rules. Just give them.
No, did
They are not being objected by the land council for the petitioner, Mr. Ghosh.
No, my A Chaudhary.
Huh?
My name is Chaudhary, A Chaudhary.
Oh, sorry. H3. I think. Huh?
Item 7.
Okay, HOD. Come on, list this matter. After 3 weeks,
Can you be me pattern, my lord? Your lord is a retired person, my lord.
very difficult.
So that is my.
Keeping in, how many parts are Mr. Bhatt? Metal remains part hard. We'll make it part hard. After
Okay.
3 weeks.
All right.
Can a date be just tentatively?
After 3 weeks, you find out. Exact the applicable provisions.
I will do.
It's not that simple as he is trying to project also.
I will,
Equally you-
come.
Equally you too.
Yes.
He may have some right, but then.
Yes, yes, yes. I'm not
he
saying I have
because
actually
of
right
his,
that I am
his
entitled.
conduct, he may not entitled.
Yes, 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 of course. Of course,
Having
otherwise-
entitled, he may not be
Yes, yes.
provided.
Will. Alright, so let me know. Bihu hai na, 24 to 30. But the petitioner was added to punishment of stoppage of 2 inch with immediate effect, my lord. But the order was not communicated to him, my lord.
Hmm.
Lordship.
Yes,
And even my lord, the inquiry report was also not even supplied to me, my lord.
Inquiry order, inquiry.
Yeah, inquiry report as well as the order of punishment has not been provided to me, my lord.
What is this?
Lordship, we have filed a affidavit, Lordship.
Saying what?
And
They have silent, my lord.
No, it's the only ground.
Yes, my lord.
It's a
Yes,
discipline
sir.
proceeding. If the inquiry report and the punishment is not
Yes,
handed over to the petitioner, matter ends there.
Yes, my
Lordship
lord.
may kindly come to.
We'll set aside and go back, remand it back.
Lordship
But
may,
he already retired, my lord. The area salary he will get, my lord. The two given, my lord.
he is retired in 2020 back.
And there is no such punishment, my lord. We don't know.
Lordship may kindly come to
Are
page
you
number
admitting
36,
that
Lordship.
the inquiry report was not punished?
No, Lordship. Lordship may kindly come to page number 36, Lordship.
36. Of what?
Of
Your
my
affidavit.
opposition, Lordship.
36 is the last page.
Lordship.
36 is last page.
Not last page.
But there affidavit, my lord. Respond number, my lord, 6, my lord.
Hmm.
6 affidavit, my lord. it was-
Affidavit dated 24/3/24, Lordship.
Affidavit filed by respondent number 5.
Respond
There's
number
no
6, Lordship.
respondent number
But
6.
there's a, it was filed on 24/3/2023, my lord.
Filed on 24/3/24.
23.
By whom?
By the respond number 6, my lord.
Respond number 6, Lordship. We had a
Your page runs up to
Last page, my lord,
your page.
36, my lord. Here. The affidavit start, my lord, from page number 34, respond number 6, my lord.
Lordship may kindly come to
Madam, just wait. It's not available.
point 6 will also go.
When did you file?
Affidavit,
Respondent number 6.
respond number 6,
5 is there. Who is 5?
Lordship.
Who is respondent number 5?
But 5 is, my lord, SP border, my lord.
It's there.
And
Where, my lord, he
But
was
6 is
last,
not there.
he was last posted, my lord.
Affidavit and respondent 6 is not there. It's
So-
not on the record.
Lordship.
Huh?
Superintendent Police Naga, Lordship. Respond number 6.
It's not there.
Lordship. Lordship, in
Not
that case,
Mr. So-and-so learned call. Well, we'll place it, fix it for some other day. We'll ask him.
hearing, Lordship.
It already hearing, my lord.
It's in the hearing only.
Lordship.
Not Mr. So-and-so learned counsel for the petition. Let's go, Thakur.
Yes, my lord.
MS.
8 Talukdar, Lordship.
Talukdar,
For all the respondents,
London State Council
Lordship.
for all the respondents. Submits that an affidavit in opposition has been filed on behalf of respondent number 6. However, same is not available with the record. Raised it to verify and take the affidavit along with the present, along with the writ petition, along with the record, along with the writ petition. With the, not along with the writ petition, comma, if it is filed. List after
And the mayor,
3
for
weeks.
date, my lord.
3 weeks.
Okay.
You
Day for
enjoy
date, my lord.
you enjoy the Bihu and come back.
After you, my lord.
When we-
You visit you.
Deeply obliged, Lordship.
What is this, sir?
My lord, matter relates to, my lord, compassionate family pension scheme. My lord, the petitioner before my lord is the two daughters, my lord, of the deceased father. Now, my lord, they have a mother who is the respondent, And what has happened, my lord, the mother by bypassing us, my lord, enjoying the family pension full with the full extent, my lord.
Stepmother.
Stepmother, my lord. That word I am not uttering, my lord. She
No,
is
no, it's
our
okay. It's
stepmother.
not that.
Now, my lord, as per the scheme which has been provided by the government, my lord, is a compassionate family.
It's okay. It's not an issue. If
Well-
the family pension is being paid to
Paid to
her,
her. Paid to
she is
her,
not taking care
taking care
of you.
of me. That is the
Take
simple
care.
case.
My lord, will
Will direct
They-
you to take care.
My lord,
Or if you agree, how much you
my
get,
lord,
Pension.
my
how
lord,
much are being paid? How much are being paid to you?
my lord,
It's a
nothing.
one-time payment.
My lord, my pension has been suspended, my
My
lord,
lord, that-
because
That's
of
why
the
I'm saying,
interim
how
order.
much you are getting.
My lord, my lord, and the family pension, my lord, that will be in reduced amount.
No, no, how
And-
much, how much?
That I cannot at this stage say, my lord.
40,000 may she will get.
No, whatever entitled,
My lord,
will
Whatever entitled.
direct them to pay her,
My lord.
but out of the 50% you pay to
My
her.
lord,
My lord.
I have a, my lord, full bench judgment, my lord.
Only
What?
for
In the
this
light of the,
different
my lord, we are
context.
taking care, but the allegation is false, my lord.
No, no.
And if they are not satisfied, they can go to the appropriate court, my lord, for claiming maintenance, my lord. That is the full bench judgment, my lord.
No, no, that
In the
is-
light of the full bench judgment, their petition is not maintainable.
My lord, may I?
Paragraph 23, my lord.
You also provide in the event.
Paragraph
case of
23.
Other person who are entitled to the benefits of family pension in terms of the non-contributing, including a second or further wives, in case where the purchase are governed by the government and are not appropriately maintained that the eldest of the serving or wife to whom the pension will be paid, the remaining will be removed from family. Under the law, will not a claim for the payment of the committee by the state of the government. Okay. Instead of those on their own volition of the review, yes,
My lord,
who is the estate? We'll ask the estate. Why unnecessary they will send them for claiming maintenance? Yes, estate. Who is paying?
It's a pension department, man.
Who is the pension department? Yes. See, there's a record while this, as per this code, while this writ petition was moved, that prima facie, respondent number 6,
My lord.
who is,
next one, 9, my lord.
9, who is receiving the family pension, appears to be not maintaining the petitioner. Therefore, that has been suspended, right?
Yes.
My lord, yes,
The
my lord.
payment has been suspended. Now, he may be correct in case if a person who
There is a dispute between.
claims to be not properly
Satisfactory.
maintained by the person who is receiving the family pension. In that case, they have to approach for maintenance. What this court is suggesting, and there's not an absolute bar also. You are correct, but then it says, if you wish, in the facts and circumstances, it appears that you are not maintaining properly.
My lord,
Let us not go to the technicality. It's bigger amount.
my lord,
It's a small amount.
my lord. We
And,
are maintaining, my lord. The allegation
So
is totally false, my lord.
if you decide, as per the full bench,
My lord.
if you wish to share them, make a payment to,
PPO is not, it is only one PPO.
huh?
PPO, for pension, there is a PPO number.
No, it's a,
One number, but thereafter, they have made a agreement between them, then how much, then only that agreement, the pension is released in the PPO and the name of the after exponent number 9.
work it out. 50-50,
No, my lord. It's absolutely wrong, my lord. How it can be 50-50?
50-50.
My lord, I have other liabilities, my lord. The only, my lord, they are
No, how can you not refuse to maintain her?
my lord. No, my lord. My lord, we are maintaining the allegation is false.
Who sees? Are you disowning her?
No, we are not disowning, my lord.
So as how much you are paying him by maintaining?
My lord, my lord, we have filed.
Sir,
No,
it's
my
a
lord, it's 50.
mother and
I have other
mother and
liabilities
daughter.
also.
No, my lord, both are daughters, my lord.
Well,
We are only claiming for petitioner number 2, my lord,
Okay,
because she is a minor.
who is receiving?
My lord, my mother is, stepmother is receiving, my lord,
Okay.
before this petition is.
my lord, we are maintaining her, we have also made an insurance policy in her name, my lord. In her name, the 2 lakhs rupees has been deposited in the insurance, my lord, for her, my lord. And with all these allegations, this writ petition has been filed at the instigation of the writ petition number 1.
Who is responsible number
Writ
one?
petition number 1 is the elder sister. Writ petition number 1. Petition to go.
These are all, my lord.
Claiming in favor of the
By
respondent.
granting you, sir, 2 weeks time, come back, try to settle it.
My lord,
Forget about the technicalities. It's between the daughter and the mother. No matter, you may be a stepmother. All right?
Miles.
Well, I'm just granting, if you cannot, we'll decide on its own merit.
my lord,
All right?
my lord, we are paying, we have
Well,
also
see,
given insurance policy also. If they are not
I'm not
satisfied,
saying-
let them go to the court, civil court, my lord. Let them go to civil court, my lord, in the light of the full wealth decision.
We'll see, while granting you sometime, 2 weeks time, come back,
My lord,
heard Mr.
A.R.
A.R. Bhuya, learned counsel for the petitioner, and also heard Mr.
A.R. Sikdar.
A.R. Sigdar, learned counsel for the respondent number 9. And
my lord, my lord, there are some
I'm just-
other,
it's a, Sir,
there
it's
are
a
some other
proposal.
decision of this honorable court also, in the light of the full bench
we'll
decision.
see. See, certain things are there. I'm not saying that this is wrong. I'm not saying that I'm disagreeing with it. If I have a respectful disagreement, definitely I'll decide and send it for larger bench and place before the chief. I'm not on that. So and so, huh? Considering the issue in the present petition, next para, huh? Which is with regard to considering the issue raised in this writ petition, issue involved in this writ petition, comma, to the effect, which relates to claim of family, what?
Family pension. no.
Compassionate family
Compassionate
pension and
family pension.
family pension.
Paid, which is being paid to the respondent number 9,
9.
comma. This court is of the view that since the petitioner and the petitioner is the daughter and the respondent number is the mother, comma. 2 weeks time is granted to the learned counsel for the parties to make an effort, make an endeavor to settle the matter between the petitioner and the respondent number 9. It is expected that the learned counsels for the parties will give their best effort to settle the matter
Outside the court.
outside the court.
My lord, we will
List-
communicate.
list after 2 weeks. We'll
Right.
give that date. If you cannot, we'll decide.
My lord.
Obliged.
Item 14 to 27, my lord, some of the matters I am appearing, my lord. 17 to 23, I'm praying for some accommodation.
What accommodation?
But yeah, my lord, my difficulty is, my lord, I am led by senior counsel, Mr. K. Shori. Today he is not available, my lord. So that is why I am praying for some.
What is there?
Your lordship may, a little bit of hearing may be required. Your lordship, fix it immediately after the opening of the picture.
Wait, what is the case? What is the case?
This is regarding, my lord, termination of contractual employees, my lord.
So what is their right? What is the right of contractual employee?
That is.
Then, other than the appointment by the contractual employee, what has happened, they have replaced one set of ad hoc employees by another set of ad hoc employees. We have given
We'll
the,
interpret that also. You
Yes.
go for regular selection process. Both has to go. Petitioner as well as those who have been appointed.
since he is seeking an
Because
accommodation
today
for
I'm
today.
little
so
bit
your
What
lordship
is
may-
the- why senior lawyer and he's there? similar matter, once in your.
Yes, my learned senior is
No,
representing
no,
some of them,
learned senior, one learned senior lawyer is enough.
but still, my client has engaged the senior counsel, that is why.
Okay,
So, since he is not available today,
think about it at 2 o'clock. We'll take
My
it
lord,
up.
instead of two, my lord,
Lordship, in fact, they have informed us yesterday itself.
What is there?
So Lordship will take up this matter after vacation.
All go, no.
no, my lord, today.
Petitioner as well as those who have been, appointed in their place. All has to go.
Your lordship may, my lord, no,
Huh?
no. Most of the councils are under an impression that this will take a adjournment. My lord, may I pray, my lord, we are not seeking any adjournment as such. My lord, let it be on Thursday next, my lord.
We are out of station after second,
Second is third, I'm seeking third.
after the second, third.
After second is third only, that's why I'm seeking a prayer.
What is
third.
the extent of the government? It is the
Lordship,
government or
this
who?
way. We are
corporation,
Corporation. Who is for corporation? Yes, then
We have already filed our affidavit, Lordship.
saying what?
Case is otherwise, Lordship, it was, a decision was.
But I have come across, some of them have been appointed after due selection process.
Yes,
Huh?
That is there.
Some of them.
Lordship. In the affidavit, Lordship, we have denied that.
So how
Actually,
you have appointed them?
my lord, my lord, let me say, what has happened, my lord? Some of them have come through a selection process, but the crux of the issue is that there is no advertisement. Now, your lordship has now the Umadavi case also. I have found one judgment which has now diluted a Umadavi's case, that if someone has come through some sort of selection process and they have worked for long years, then their cases may be considered. One recent judgment, I think, last month it has come. So I'm seeking only an accommodation since they have told.
Friday.
From my lord,
we are out of station.
It's okay. Corporation, who has issued the impugn order?
Lordship, my presence. also required.
Corporation. Huh?
Since representing the department.
Have you filed the affidavit?
This matter learned AD side also.
Huh?
Lordship, the affidavit filed by the.
my lord.
Corporation will cover. So we'll go to the. Go
My
by
lord,
the
may I
affidavit.
pray, my lord? May I,
My lord.
third, my lord, I am also, I will be in Imphal on Friday next, my lord.
Third.
Third.
And in that case,
Appointment made to
step.
dispose of the
third Mr.
BD.
Bidiko, that is senior counsel assisted by,
Chasing option.
and
NJ Katani.
Mr. NJ Katania. Can you appear?
In some of the matters, I am appearing.
How can
Yes,
you
I
appear? Are you not a,
No, I am
Government
standing
counsel.
counsel for the education department only.
okay, you can do that.
Yes, madam.
Very, very lucky. Sometimes this side,
Yes,
sometimes that side. Flip flop. And who else are there?
Lordship, I am
25, I am.
That's okay, will not say. This should be common order. Comma, so and so for, and so and so. How many? 3 of you?
No, I am only on one case, 25.
I'm
Oh,
appearing
for
for
land council for the petition. It's okay. And
I-
Mr.
yes, Lordship, I am appearing for ASTC.
With them. Next para has agreed to be the learning council for the petition, the parties list this matter on 03/04/20.
04, yes.
In item number 15, madam, there is an interim order, madam. 1/5.
Interim order passed, if any, in this batch of writ petition, if any, shall continue till the next day. Are you still working?
Yes, well, some
Some
three,
in-
three
in-
or
some
three
of
In
them-
item number 15, those persons are working, madam.
How many people?
three.
Three
people is out.
7.
I have come across some of the petitioner have prayed that you should be allowed to appear in the regular selection process in some of the petitioners.
Well,
Well,
I'm,
I was reading yesterday night.
well, I'm appearing for
That
the.
I find it very, very fair submission. No, other than that, there cannot be. We can, if you think about it, if wrongly, rightly, I mean, they can be allowed to participate in a regular process, which you may take up.
That we have accepted in our affidavit.
No,
No, you are-
there is a problem
Age
regarding
relaxation.
their age.
Lordship.
Considering relaxing the age, that also you take instruction.
That may be.
Because relaxation of age would not prejudice anybody.
Yes.
So some of the petition I have seen, that I find it very fair. That's why I was insisting to dispose of the matter in that line. Allow them participate and relax the edge. Okay, on third, we'll see.
Obliged.
Obliged.
That's it.